ನಂಬರ್ 30 ಅಂತ 30. ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಸರ್ಕಾರವು ಕೈಬಿಟ್ಟಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಈ ಜಮೀನಿಗೆ ಬದಲಿ ಜನರು ಕೇಳಿರುವ ವಿಚಾರ. Then, my lord, please be kind enough to turn to page 153, second paragraph. ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಸರ್ಕಾರವು ಭೂಸ್ವಾಧೀನ ನಡುವಳಿಯಿಂದ ಕೈಬಿಡಲಾಗಿದ್ದರೂ ಕೂಡ ಈ ಜಮೀನನ್ನು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿರುವ ಸಮಯದಲ್ಲಿ ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಸಹ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿಕೊಂಡ ಉದ್ಯಾನವನ, ರಸ್ತೆ ಹಾಗೂ ನಿವೇಶನಗಳನ್ನು ರಚಿಸಿ ಫಲಾನುಭವಿಗಳಿಗೆ ನಿವೇಶನವನ್ನು ವಿತರಣೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಬಡಾವಣೆ ನಕ್ಷೆ ಪ್ರತಿ ಅನುಬಂಧ 3 ಮತ್ತು ಆಕಾಂಕ್ಷೆ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲಾಗುವ ಮಾಹಿತಿ ಅನುಬಂಧ 4. BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಇವರಿಂದ ಪರಿವರ್ತನೆಯಾದ 3 ಎಕರೆ 16 ಎಕರೆ ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವ ಶ್ರೀಮತಿ ಪಾರ್ವತಿ ವಿಜಯನಗರ ಬೆಂಗಳೂರು ಇವರು ದಿನಾಂಕ 23/3/2014
ಖರೀದಿಸುವ ಯಾವುದು
ಅಲ್ಲ, ಖರೀದಿಸಿಲ್ಲ, ನಾ ಇರೋದು ಅದು ಗಿಫ್ಟ್, ಅದು ಗಿಫ್ಟ್, ಅದು ಇವ್ರು ಬರ್ದಿದ್ದಾರೆ. ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವ
ಪರಿವರ್ತನೆಯಾದ 3 ಸೋನ್ಸು
ಜಮೀನು
ಖರೀದಿಸಿರುವ
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅವರು. ದಟ್ ಪಾಸಿಬಲಿ ದಿಸ್ ಖರೀದಿಸಿರುವ ರೆಫರ್ಸ್ ಟು ಮಲ್ಲಿಕಾರ್ಜುನ್ ಸ್ವಾಮಿ. ದಟ್ ಈಸ್ ಟು ಬಿ ಚಾರಿಟಬಲ್ ಟು ದಿ ಡ್ರಾಫ್ಟರ್ ಆಫ್ ದಿಸ್ ರೆಸಲ್ಯೂಷನ್. BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಇವರಿಂದ ಪರಿವರ್ತನೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವ ಶ್ರೀಮತಿ ಪಾರ್ವತಿ
ಖರೀದಿಸಿರುವ ಶ್ರೀಮತಿ ಪಾರ್ವತಿ.
ದಟ್ ಈಸ್ ಹೌ ಇಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್.
ಆಲ್ ರೈಟ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್.
ವಿಜಯನಗರ ವಾಸಿ ಬೆಂಗಳೂರು ಇವರು ದಿನಾಂಕ 23/3/2000 ಮನವಿ ಸಲ್ಲಿಸಿ ತಮಗೆ ಸೇರಿದ ಜಮೀನಿನಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಈಗಾಗಲೇ ಬಡಾವಣೆ ರಚಿಸಿ ನಿವೇಶನಗಳನ್ನು ಹಂಚಲಾಗಿದೆ ಹಾಗೂ ಉದ್ಯಾನವನ ಮತ್ತು ರಸ್ತೆಯನ್ನು ನಿರ್ಮಿಸುವುದರಿಂದ ನಮ್ಮ ಜಮೀನಿಗೆ ಬದಲಿಗೆ ಅಷ್ಟೇ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಸಮಾನಾಂತರದ ಬಡಾವಣೆಯಲ್ಲಿ ನೀಡಿರುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರ ಶ್ರೀಮತಿ ಪಾರ್ವತಮ್ಮ ಇವರಿಗೆ ಮಾರುಕಟ್ಟೆ ದಂಡವು ಜಮೀನಿನ ಪರಿಹಾರ ನೀಡುವುದಾಗಿಯೋ ಅಥವಾ 40-60 ಅನುಪಾತದಲ್ಲಿ ನಿವೇಶನ ನೀಡುವುದಾಗಿ ತಿಳಿಸಲಾಗಿತ್ತು. ಆದರೆ ಪ್ರಾಧಿಕಾರದ ಈ ಸಲಹೆಗೆ ಅವರು ಒಪ್ಪಿಗೆ ನೀಡಿದ್ದೇ ಇದ್ದು ಬದಲಿ ಜಮೀನು ನೀಡುವಂತೆ ಒತ್ತಾಯಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು ದೇವನೂರು 3ನೇ ಹಂತ ಬಡಾವಣೆ ನಿರ್ಮಿಸುವ ಸಮಯದಲ್ಲಿ ಸರ್ಕಾರ ಕೈಬಿಟ್ಟಿರುವ ಕೆಸರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ 3 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿಕೊಂಡಿರುವುದರಿಂದ ಭೂಮಾಲೀಕರ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸುವ ವಿಚಾರದಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವ ಸಂಬಂಧ ವಿಷಯವನ್ನು ಸಭೆಗೆ ಮಂಡಿಸಲಾಗಿತ್ತು. Now, my lord, please be kind enough to turn to page 152. 153, I'm sorry. 154. 154, my lord, on top.
I'm there. Yes.
Top of the page.
I'm there.
Yes. ದಿನಾಂಕ 10/11/2002 ನಡೆದ ಸಭೆಯಲ್ಲಿ ವಿಸ್ತೃತ ಚರ್ಚೆ ನಡೆದು ಸಂಪೂರ್ಣ ಮಾಹಿತಿಯೊಂದಿಗೆ ಮುಂದಿನ ಸಭೆಗೆ ಮಂಡಿಸಲು ತಿಳಿಸಿದ ವಿಷಯವನ್ನು ಮುಂದೂಡಲಾಗಿದೆ. ಮಾನ್ಯ ಪ್ರಾಧಿಕಾರ ಸಭೆಯ ತೀರ್ಮಾನದ ಪ್ರಕಾರ ಪ್ರಕರಣದಲ್ಲಿ ಸಮಗ್ರವಾಗಿ ಸ್ಥಳ ತನಿಖೆಯೊಂದಿಗೆ ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಕಂಡ ಮಾಹಿತಿಯನ್ನು ಸಭೆಯ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. And then, my lord, there are all these sites which are identified. And now please be kind enough to turn to the next page, at page 155. ಮೇಲಿನ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಹಲವು ಪೂರ್ಣ ನಿವೇಶನಗಳು ಹಾಗೂ ಹಲವು ಭಾಗಶಃ ನಿವೇಶನಗಳು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗೂ ಸೇರಿರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಪ್ರಕಾರ ರಚಿಸಿರುವ ನಿವೇಶನಗಳನ್ನು ಮಂಜೂರು ಮಾಡಿದ್ದು ಈವರೆಗೂ 15 ಪ್ರಕರಣಗಳಲ್ಲಿ ಕ್ರಯಪತ್ರ ನೀಡಲಾಗಿದೆ. ದಟ್ ಈಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದೋಸ್ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ದೋಸ್ ಸೈಟ್ಸ್. ಅದಲ್ಲದೆ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466 ರಸ್ತೆ ಉದ್ಯಾನ ರಚಿಸಿದ್ದು ಸದರಿ ವಿಸ್ತೀರ್ಣದ ವಿವರಗಳು ಈ ಕೆಳಕಂಡೆ ಇರುತ್ತದೆ. Now, my lord, kindly see, my lord, 6255 square meters is the sites, and 13, and then, my lord, the road and the garden and the parks ಒಟ್ಟಾರೆ 13,759 ಚದುರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಪ್ರದೇಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಪ್ರಾಧಿಕಾರವು ದೇವನೂರು 3ನೇ ಹಂತದ ಬಡಾವಣೆ ನಿರ್ಮಿಸುವ ಸಮಯದಲ್ಲಿ ಸರ್ಕಾರ ಕೈಬಿಟ್ಟಿರುವ ಕೆಸರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ 3 ಎಕರೆ 16 ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಉಪಯೋಗಿಸಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ಸಾರ್ವಜನಿಕ ಉಪಯೋಗಕ್ಕೆ ನೀಡುವುದರಿಂದ ಭೂಮಾಲೀಕರ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸುವ ವಿಚಾರದಲ್ಲಿ ಪ್ರಾಧಿಕಾರ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವ ಸಂಬಂಧ ವಿಷಯವನ್ನು ಸಭೆಗೆ ಮಂಡಿಸಲಾಗಿದೆ. ನಿರ್ಣಯ: ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಕೈಬಿಡಲಾಗಿದ್ದರೂ ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ಉಪಯೋಗಿಸಿಕೊಂಡಿದ್ದು ಪ್ರಾಧಿಕಾರದಿಂದ ತಪ್ಪಾಗಿರುವುದರಿಂದ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ 3 ಎಕರೆ 16 ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ಉಪಯೋಗಿಸಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಿ ನಿವೇಶನ, ಉದ್ಯಾನವನ, ರಸ್ತೆಗಳನ್ನು ಸಾರ್ವಜನಿಕ ಉಪಯೋಗಕ್ಕಾಗಿ ಮೇಲ್ಕಂಡೆ ನೀಡಿರುವುದರಿಂದ ಪ್ರಾಧಿಕಾರ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದು ಅಭಿವೃದ್ಧಿ ಪಡಿಸದೇ ಇರುವ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ಬದಲಿಯಾಗಿ ನೀಡುವುದು ಎಂದು ತೀರ್ಮಾನವಾಯಿತು. Now, my lord, this next, your lordship may kindly go to page 157. ಸದರಿ 3 ಎಕರೆ 14 ಎಕರೆ ಜಮೀನನ್ನು ಶ್ರೀ
I've seen and marked already.
your lordship.
Yes.
Now, my lord, the point I want to make to your lordship is this. Kindly see the amount of compensation with respect to this 3 acres 16 guntas which is assessed and deposited. It is about 3,24,000 rupees. Are you giving property worth 3,24,000 rupees? No application of mind on this. Well, you yourself said the property is worth 3,24,000 rupees. And what is the value at which these 14 sites that are given? No application of mind by the authority, my lord. You will exchange cheese for chalk. Is that what is being done? That's what has been done. That's the allegation. Should that not be inquired?
Is it the other way around?
No, I'm saying the 3 acres 16 guntas of 3,24,000, that is chalk, and what you have given is cheese.
Yes.
So, my lord, you get cheese for chalk.
Chalk and cheese. Yes.
I'm now putting it the other way. Yes, my lord. That's what has happened in this case. You have given them a valuable property in exchange for a property which was very much less in value than the property which you are given. My lord, may be right, may be wrong. But
Inquiry.
My lord,
It should be inquiry.
into. That's the point, my lord. Every time we are told the same thing. And then, my lord, we are told that Brutus is an honorable man.
Yes, he is an honorable man.
Yes. That is
That is
what Mark Antony said, my lord, in the funeral oration of Julius Caesar.
Yes.
Brutus is an honorable man. Well, let it be inquired into, my lord.
You're carrying that statement further of Brutus. Not that he loved Caesar less, but he loved Rome
Hey,
more.
Rome more.
Yes.
Well, exactly. Not that
Yes.
Brutus said that, my lord, but kindly see, it's 18, my lord, your lordship now saw the resolutions. One aspect that I want your lordships to kindly note is no application of mind with respect to the value of the property, which I think, my lord, is a very important aspect when it comes to doling out public property. That I thought, my lord, was a very important aspect which the authority ought to have applied its mind. I am not asking your lordship to go into the question as to whether this is right or wrong, because that's not the subject matter of this writ petition. The question is whether undue favor shown by overlooking all these aspects. Property already vested, no question of denotification, not entitled to even one side. In spite of it, you give them 50-50 on the basis of a notification of 2015. And then, my lord, the value of the property completely ignored. How many more issues do we want for the purpose of inquiry is what I ask. And now, my lord, please be kind enough to look at the next item, my lord, seal number 19 in the list. This is where, my lord, your lordships ask a pointed question always. What is the connection between the petitioner and all this? My lord, all this happens when the petitioner is in office, because he was the chief minister. Yes, of course, 2014-17 resolution was when he was the chief minister.
You said item number 19.
No, my lord, 18.
18.
18, all this happens.
18, yes, he was chief minister.
He was chief minister.
Not in 19.
No. I'm not saying, my lord, 2013, 2018. I'm talking about 2017.
Serial number 19.
Serial number 18. I'm
18.
sorry. I possibly was.
That's
I'm talking about serial number 18,
All
not 2018.
Yes.
Serial number 18 is in 2017.
Yes.
And it's such a sweet resolution. Where everything, yes, we made a mistake, we have done this, we asked her, she said no, what can we do? We have to concede to what she's saying. But how much more bending backwards do you want? Is what I ask myself. I have never come across, my lord, of authority bending backwards like this. Everything, everything is to be done to suit the requirement of the applicant. And now, my lord, please be kind enough to turn to the next one. Seal number 19. Letter of Muda to Principal Secretary seeking clarification. However, no clarification was elicited by any officers. Despite the same, Muda went ahead. Then, my lord, 2510, petitioner requested for compensatory sites once again.
Petitioner requested?
No, I mean, petitioner means the mistake. My lord. I agree. It should have been. I apologize.
If this was there, no argument was necessary.
ಇಲ್ಲ ಆವಾಗಲೇ ಹೇಳ್ತಾರೆ
Nobody's argument was
ಇಲ್ಲ ಆವಾಗಲೇ ಹೇಳ್ತಾರೆ ನಾವು 2021 ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂತಾರೆ ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂತಾರೆ 2021 ನಾವ್ ಇರ್ಲಿಲ್ಲ ಅಂತಾರೆ
ಇಲ್ಲ ಆಯ್ತು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ
You was the leader. No, man, it's a mistake. It's a mistake. It's okay.
Yes.
Yeah, please.
So it is not the petitioner.
No, it's the petitioner's wife. Yes. It is a mistake.
Yes.
Now, my lord, between 17 and 21, nothing is done. Clarification also not received from the principal secretary of the government. What do we do about this? Well, what would be the natural course to await? No, it doesn't happen that way. Now, my lord, please see the order dated 30th of December 2021 issued by Muda allotting 38,284 square feet to the petitioner's wife. That is the one, my lord, document number 23 at page 169 of the statement of objections.
169.
Yes.
Yes. Yes, sir.
As your lordship will kindly see, my lord, this is dated 30th of December 2021. And if your lordship will kindly go over to the page at page 170, is the order. And in this, my lord, the order is on the basis of the resolutions passed on 15/12/2017 and 30th of December 2017.
Yes.
Your lordship gets it at page 169. This is the link, the vital link that your lordships have always been asking us. Give me that. What is the link between the petitioner and what you're complaining of? The 2017 resolutions are the link. And but for the 2017 resolutions, this would not have happened. All this would not have happened. And this is a chain of events. Please do not therefore look at it in isolation.
All right. Link in the chain of events.
Yes, my lord, this is a vital link. And these are very important events that have taken place, which has led to the allotment of these sites in favor of the petitioner's wife. That is on 5/1/2022.
Yes.
5/1/2022 is not a standalone document. Now, my lord, please look at page 170 of this document, if I may trouble your lordships, my lord. My lord, page 170. That 50/50 formula has been applied.
Yes, sir.
ಮೈಸೂರು ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳದೆ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಬಾಬ್ತು ಪ್ರಾಧಿಕಾರದ ನಿರ್ಣಯ ದಿನಾಂಕ 20/11. Oh, I'm sorry, my lord, page 169 at 170.
Yes.
ರಂತೆ ಪ್ರಸ್ತಾವ.
You can read, sir. I'm all ears. Yes.
I know, my lord, your lordships are not only ears, your lordships also have the mind with me.
Of course, yes. That is yes.
That's more important for us, my lord.
Ears with mind on it. Yes. No, I was just searching for something.
No, I'm sorry.
Because,
I'm sorry if I
see,
interrupt.
To take it a little further, 14 sale deeds were registered in favor of so-and-so
Yes.
on 12/1/2022.
Yes.
In terms of that scheme,
Yes.
then immediately it is stopped.
Yes. Yes.
On 14/3/23 saying that no
Yes.
allocation of
Yes,
compensatory
yes,
sites
yes.
henceforth.
Yes, yes. Answer is yes. Answer to your lordship question is yes.
All right, yes.
And because on 14/3, my lord, they issued saying stop all further allocation of sites. That is the document. my lord,
Was this the last chunk of allocation, not only to the petitioner's wife, but to others also?
But I'm unable to answer your question this way or that. I don't know.
All right, just,
I
they will
I,
answer, I guess.
I don't know whether after 12/1/2022 and especially after the government order dated 14/3/2023, has there been any further
I'm not, after 14/3 Allah.
after 12/1?
Prior to 14/3/23, whether these 14 sites were allotted to the petitioner's wife alone or to several others, one question. The next is, after 14/3/2023, was everything stopped?
I'm
Those
given to
are
understand,
the two clarifications.
I'm given to understand, my lord, that after 14/3/2023, everything was stopped.
All right. Yes.
Whether anybody else
After
has
14/3/2023?
no, before.
Before, yes.
That information, my lord, I don't think I'm able to answer your lordship right away
Okay.
because I don't have that information. Now, my lord, now your lordship may kindly see, my lord, on 14/3 when the government says stop it, then kindly see, my lord, on seal number 27. The one other aspect, my lord, which may require your lordship's consideration is what is mentioned at seal number 26.
Yes, sir.
Government of Karnataka cancelled the resolution dated 14/9/2020. We are not able to lay our hands on this resolution. So I am afraid, my lord, I am not able to assist your lordships as to what is the cancellation that was done, which is available at page 281.
So what is that resolution 2020, 14/9/2020?
My lord, I'm not able to help your lordships on that, my lord. That's fine.
All right. Yes.
My lord, what that I'm given to understand.
Page 282.
No, that is all right. That, my lord, is, if your lordship will kindly see 2710, that may show some light on what is this. Give me that. This one, page 281. My lord, kindly see page 281, my lord. It seems to throw some light as to what is this.
282.
Yes, correct, my lord. 282. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮೈಸೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ
that I have
ದಿನಾಂಕ
seen.
so and so.
282.
ಪರಿಹಾರ ನೀಡದೆ ಜಮೀನನ್ನು ಉಪಯೋಗಿಸಿದ
50/50 scheme was withdrawn.
Scheme has been withdrawn. ರದ್ದುಪಡಿಸಲಾಗಿದೆ.
Cancelled. Withdrawn.
So, and then, my lord, there is so much of maladministration in Muda that the government, my lord, had appointed a committee and kindly see, my lord, serial number 27
For what purpose?
to inquire generally into what all is happening in Muda.
That is nothing. There's no bearing on this.
I also see that, my lord, because there is no specific point on which they were asked. But the fact appears to be that
General maladministration.
that is a general, I agree. That between 1996 and 1999, I mean, this is not there in this. I would trouble your lordship to kindly just note these periods.
1990?
6 to 1999, the petitioner was the deputy chief minister.
ಇದೆಯಾ ಅದು? ಇಲ್ಲ.
ಅದೊಂದು ಮಿಟ್ಟೋಗಿದೆ.
Most important bit.
ಅದಕ್ಕೋಸ್ಕರ ಅಧ್ಯಕ್ಷರು you know written that no. I'm sorry, my lord, I understand.
Right.
ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ ಅದನ್ನ ಬಿಟ್ಟೋಗಿತ್ತು ಅದಕ್ಕೆ ಶುರು ಮಾಡಿದೆ. 1996 to 1999, my lord, the petitioner was deputy chief minister.
Deputy Chief Minister.
Yes. 2004 to 2000, I'm giving the dates which are relevant. 2004 to 2005, he was again a deputy chief minister.
1 year.
Yes.
ಆಮೇಲೆ
The first stint as chief minister was, my lord, between 2013 to 2018.
18.
And thereafter, my lord, the second stint is from May 2023.
One moment.
We are concerned with the property, my lord, bearing number survey number 464,
ಕೆಸರೆ
measuring
ಗ್ರಾಮ.
3 acres and 16 gundas.
ಕೆಸರೆ ಗ್ರಾಮ ಕಸ್ಬಾ.
Exactly, my lord, exactly.
Yes.
My lord, this property was originally owned by one Ninga.
Granted.
Yes, my lord. It was granted and he was the owner. And he, my lord, had 3 sons. Mallaya, Mailaraya and Devaraju. My lord, Mallaya and Devaraj relinquished their right in favor of Mailaraya. That your lordship gets it, my lord, at serial number 2 in the list of dates. Relinquishment deed by Mallaya and Devaraju over survey number 464 in favor of Mailaraya. Therefore, my lord, Devaraju had no right. It was property was owned by Mailaraya. It is noted that Devaraju name is shown in the revenue entries after Ninga and the name of Mailaraya is not depicted in the revenue entries. Then, my lord, I am going to skip to a few things. Then your lordship may come to serial number 4. In 1991, Karnataka Urban Development Authority's incentive scheme for voluntary surrender of land rules 1991 came into force, while GO dated 29th of January 1994, retrospectively from the year 1991. According to the rules, a person is entitled to 4,800 square feet when the land is acquired between 3 acres to 4 acres. That is, my lord, they were entitled to, my lord, 2 sites. If the
Between
land
3
is in excess of 3 acres.
3 acres.
My lordship may look at the rules, my lord. Your lordship may look at the statement.
All
of
right.
ex-
ನೀವು Yes.
Then, my lord, please look at serial number 6. No, I'm going to skip a few dates, my lord. May not be.
No
It is given only for the
No, you
purpose of
can-
convenience. I'm
Narrate all the dates, no problem. But rules will go later.
very well, very well.
Yes.
Now, my lord, please look at serial number 6.
Hmm.
Government of Karnataka acquisition of land for development of Devanuru third phase by Muda, 3 acres 16 guntas of survey number 464 was mentioned in notification. Notification reflected late Sri Ninga's name. My lord, the notification is available for your lordship's consideration. Now, my lord, kindly see interestingly what happens is serial number 8.
Hmm.
Devaraju sought for denotification of land.
Devaraja was not the owner.
No,
Mailaraya was the owner.
exactly.
Hmm.
Mailaraya was the owner because of the 1968 relinquishment
All
deed.
right. Yes.
Devaraju sought for denotification of the land. Endorsement of Muda recommending denotification of land, that is on 30th of August 1997. And now, my lord, final notification issued on 20th of August 1997 where this property is acquired. It is at serial number 40.
It was not yet denotified.
No, it was in fact, this is the final notification.
No. But what is this denotification?
The recommendation. He made an application, there is a recommendation.
Recommendation on 38/1997.
Yes, correct.
All right. But just before that, a final notification is issued.
Yes,
All right.
exactly. And the notification and that relevant property, my lord, is at serial number 40 of the notification. There are number of properties. My lord. Then, my lord, 30th of March 1998, an award is passed. And the amount, my lord, has already been deposited in the revenue treasury. It has been deposited. So with that, my lord, acquisition is over now. There is nothing more to be done. Then comes the notification, my lord, at serial number 11. 18/5/1998, where there is a denotification of the survey number 464. This is where, my lord, the problem starts.
This was the only land denotified or anything else?
My lord, I'll check, my lord. I'll check until I answer your lordship's question. My lord, kindly, I tell you, lordship, my lord.
No problem. Later you can tell.
My lord, answer to your lordship question is only this land.
Only this land?
Yes. It is at page 109.
Nobody had applied for denotification?
No, my lord, I don't know whether anybody had applied, but the fact of the matter is that the denotification of 18/5/1998 is pertaining only to this land.
All right.
And we are given the reference number, my lord, as a statement of objections.
Huh.
Then, my lord, interestingly, on 25/8/2004, Devaraj, my lord, sold this property to B.M. Mallikarjun, my lord, who is the brother-in-law of the petitioner. And thereafter, there is a site inspection report. My lord, your lordship gets a site inspection report. Is it in your new list of dates, 5/3/25?
Is there?
My lord, there is
Yes.
one site inspection report
He has
of
taken this.
5th of March 2005. Your lordships have seen that, my lord.
2 inspections are done. DC says he himself has inspected
Yes,
it and
correct.
conversion is granted.
Correct,
Yes.
correct. In that, I'm going to point out some very telling facts,
Huh.
which I'll come to. Shall I do it right now, my lord?
Yes, sir.
Please be kind enough to turn to page 125.
Of the objections,
Yes, my lord. My lord, page 125 is a communication from the Tahsildar to the Deputy Commissioner dated 5/3/2005.
Hmm.
Please be kind enough to turn to page 126.
Hmm.
And he says, my lord, he has done an inspection on 4/3 and the last paragraph at page 126. ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಕಂಡಂತೆ ಹಾಗೂ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 32 ಎಕರೆ ಜಮೀನಿದ್ದು ಈ ಪೈಕಿ 16 ಗುಂಟೆ ಜಮೀನಿದ್ದು ಈ ಖರಾಬಿನಲ್ಲಿ 5 ಗುಂಟೆ ಆ ಖರಾಬಿದ್ದಕ್ಕೆ ನಿಯಮಾನುಸಾರ ಪರಿವರ್ತನಾ ಶುಲ್ಕ ವಿಧಿಸಿ ಉಳಿಕೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಂಜೂರು ಮಾಡಲು ವಿಶಿಷ್ಟ ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. Now please look at the next one at page 127. This, my lord, is
spot inspection.
spot inspection. ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕೋರಿ ಶ್ರೀ BM ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಬಿನ್ ಮರಿಲಿಂಗಯ್ಯ ಮೈಸೂರು ಇವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯ ಬಗ್ಗೆ ತಾರೀಕು 17/6/2005 ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿರುತ್ತೇನೆ. ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಇತರೆ ಸಿಬ್ಬಂದಿ ಹಾಜರಿದ್ದರು. ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ರವರ ಪತ್ರದ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕಾರ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಬಂದಿದ್ದು ಖಾತೆಯಾಗಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ. This is when acquisition is complete. The question of their being in possession would never arise. This is such a blatant.
No, but it was denotified.
Subsequently,
Huh?
subsequently, the denotification was in 2008.
1998.
1998.
This
Yes.
spot inspection is 2005.
Correct. But it's already acquired. Where is the question of their putting in possession?
No, that is why I asked. Recommendation was made for denotification.
Correct.
Where is the order of denotification?
Nothing, excepting, my lord, what happened on 20th, when, my lord, there was on 18/5/1998.
No, that is an order.
Notification. Yeah, that's a notification.
Then it was denotified.
Yes, it was only on 18/5/1998.
It's all right.
Yes. Yes, my lord.
We don't have auto payment.
Huh?
We don't have the auto payment.
Yeah, if your lordship says, is there a order of no denotification? We don't have it. But
Notification.
notification is 18/5/1998. It is at page 109, which
All
when your lordship asked me, is this the only property which has been denotified? My answer to your lordship's question was, yes, that's the only property which has been denotified. Now, the first question that arises, my lord, is where is the question of this denotification? How can this denotification at all be done? Is it not glaring act of doing something which is not provided by the statute? When the property is vested, where is the question of a denotification? Now, in that context, my lord, if possession has been, if they say possession is with the Devaraju, I ask myself, how did possession go to him? Nothing that is available on record for your lordships to come to a conclusion this way or that. That is the reason why, my lord, it is only in areas where it is a gray area that inquiry is required. My lord, in fact, my lord, the very fact that so much of submissions had to be made to your lordships in order to point out whether the needle of suspicion is to be pointed this way, that way, or none at all, itself indicate that something has required to be looked into. It is only that much that is required to be done today. If it was open, black or white, no inquiry is required. It is only in gray areas that inquiry is required. This is a case falling within gray area. Therefore, my lord, all that is required to be done is just inquire into it. I fail to understand, with due respects, why this case has been elevated to the level of taking your lordship's time over and over again for the simple purpose of simply an inquiry. In a situation of this kind, my lord, let us assume, my lord, the PCA Act was not there and a simple complaint had been filed, where there was no this filtration process, my lord. Let us assume it was not there. And I asked myself if a complaint had been filed with the police authorities.
ಅದಕ್ಕೆ ಫಿಲ್ಟರ್ ಬಂದಿರೋದು.
ಇಲ್ಲ, ಬಂದೆ. And it had come to your lordships under 482. I asked myself the question, would your lordship interfere? I would say no. Your lordship would have said, look, in the complaint there are some allegations. Let it be inquired into. I asked myself, why is it that same test should not be done for the purpose of 17 years? 19 is a totally different kettle of fish. 13, no?
12.
Serial number?
Kindly see, seal number 12. In 2003, despite survey number 464 is denotified, Muda forms layout, parks and roads. Sites are allotted by Muda to various persons. Now, my lord, then comes Devaraju, who says, I am the owner of the property. You have sold my land. He sells the property in favor of the petitioner's brother-in-law. And then, my lord, there is an order of conversion, and then, my lord, there is a gift in favor of his sister. It is on the basis of these documents that the sister now says, please give me compensation / alternate sites. Now, please look at that, my lord. Please look at the item number 16. 23/6/2014. Representations made by Parvati for compensatory sites. This is the representation she gives. Now, my lord, if an ordinary citizen had made an application like this, I asked myself,
No ordinary person made? No, along with this, there are other applications.
we have
No
nothing
other
on record.
application.
Nothing on record. We don't have anything on record. Nothing on record.
Then
Nothing on record.
why sites are distributed to everybody?
No. That is the sites which were distributed on somebody else's property to various persons. I'm talking about whether the real owner of a property which had been used by a public authority without going through the process of acquisition.
Right.
No such instance. This is the only instance.
Right.
Now, my lord, please look at, if an ordinary person had made an application like this, what would have been the attitude or the approach of the authority? Look, tell me who you are. What is your source of title? Please prove your title before I can even look at your representation.
And a mandamus before this court.
If that's not done, a mandamus by your lordships.
Direction to consider.
Exactly, my lord. Your lordships are right. Consider we have hundreds and thousands of cases where representations are made, not considered. Your lordships issues mandamus saying do it within 3 months, 4 months. Now, all this is not necessary in this case, my lord. It's not necessary for obvious reasons. The reasons are not far to see. That is what is required to be examined. What would the authority do if there was a representation by an ordinary citizen with respect to this, assuming that they're taking action, not sitting over it? They would say, look, there is a communication sent by one Parvati. Now, who are you? We don't have your name at all on record. We don't know who you are. Please prove your title. No such exercise. Nothing done. Straight away. Now, please look at, then the rules are amended, make it 50-50. As of 11/2/2015, it is on the basis of this rule of 2015 that 50-50 compensation is given. Lord, I have two as
50-50 compensation.
50% of the extent of land which has been unlawfully
So
occupied.
3.16 acres and about
Yes. About
half of that.
half of that. That's the formula. That's the formula in this new amended rule. Now, my lord, if a property has been acquired and the compensation has all been deposited, the question of even granting one side does not arise. Property has become the property vested in the government. Where is the question of denotification? Now, let us keep that aside for a moment. With respect to which rule will you take a decision on the representation that has been made, my lord, on 23/6/2014? It obviously must be with respect to the rule that existed at the time when the allotments were made.
60-40.
Exactly.
Hmm.
My lord, your lordship may kindly see when the allotments were made to various persons, my lord.
2004.
2004. I asked myself, how do you apply 2015 and give 50-50? If the encroachment or the illegal occupation was at that point of time, which is the rule which you will apply for the purpose of determining whether a person is entitled to, and if so, how much? By way of a
Are you accepting 60-40 entitlement?
assuming, without considering, I'm first submission is that not entitled to anything. No, of course not, my lord. Even 60-40, even two sides is not there.